Hi, my name is Mary Nix. I'm a lawyer in Dallas, Texas with a law firm of Lynn, Pinker, Hurst, and Schwegmann. I've been practicing law for about 25 years and primarily in the employment space. I do quite a bit of work with physicians and hospitals and in the healthcare industry. And I've been asked today to talk to you about employment contracts and in particular, restrictive covenants in employment contracts, how those are interpreted, things that you can do to protect yourself, things you can look for. And this is an area of the law that is, frankly, my bread and butter. I do it all the time. And so I feel I'm uniquely qualified to speak to you about these issues. And I also invite you, if you are in need of assistance or you have any questions at all, to call me, and I'd be more than happy to elaborate on anything that I talk to you about in this presentation or to answer any specific questions that you might have. So let's talk a little bit about restrictive covenants. In the United States, we're pro-competition, and that is something that's very important in our country. Competition is the backbone of our country. And so a non-compete is actually a unique animal. It is considered to be a restraint on trade. And so only certain non-compete agreements can be enforceable, and they have to jump through some hoops, jump over some obstacles in order to be considered enforceable. One thing that is very important is that contracts are typically governed by state law. So each state has its own set of laws that oversee the enforceability of restrictive covenants in an employment agreement, in addition to just the employment agreement itself. I'm going to focus on Texas law today because that's where I am. I will touch on some other states that are unique and of interest towards the end of my conversation with you. And of course, if you have any questions, if you're looking at a different state, feel free to give me a call. I'm relatively familiar with all of the laws throughout the country or can find the answer relatively quickly. So what is a restrictive covenant? A restrictive covenant typically is found inside an employment agreement. It's a set of clauses usually, and it's usually titled either restrictive covenants, or you'll see a set of clauses in your employment agreement that might be titled confidential information, non-disclosure agreement, non-compete, non-solicitation, things of that nature. And under the law, and I'm focusing on Texas law, there are some requirements in order for those restrictive covenants to be enforceable. And so you will typically see similar things, or a lawyer will, in any event, see similar things throughout different employment agreements because they've come to be accepted as the basic terms that are required for a non-compete or another type of restrictive covenant to be enforceable. So let's talk about the actual law. Under the Texas Business and Commerce Code is the governing law that oversees the restrictive covenants in Texas. And under the Business and Commerce Code, these restrictive covenants must be reasonable in many regards. They must be reasonable in scope, which means your restricted area of employment. They must be reasonable in terms of geographic area. In other words, they can't be too broad. If you have a 100-mile radius in your restrictive agreement, that has to be reasonable for your job, for what you do, and for the entity or employer for whom you work. It also has to be reasonable in duration or time limits. So you'll commonly see 6 months to 3 years in restrictive covenants. And those time limits have to be reasonable. We'll talk more about that. Another thing that is very vital to these agreements is they must be ancillary to an otherwise enforceable agreement. Usually that's just a check the box because it's usually part of an employment agreement or it is an exhibit to or referenced in an employment agreement. But a standalone non-compete agreement doesn't work because you have to have consideration. And consideration is very important. Only certain types of consideration are considered valid consideration for a restrictive covenant. So let's break that down. Consideration just simply means what I'm giving you in order to get something. So if I want to get a non-compete agreement from you, I have to give you something that the state of Texas has determined to be reasonable consideration for a non-compete. In the state of Texas, what has been determined by the Supreme Court of Texas is that there are a few items that can be considered reasonable consideration. One is the provision of confidential information. Another is the provision of equity or ownership interest. Another is a provision of goodwill, meaningful goodwill. And another is specialized training. And it has to be legitimately specialized training in order to support a non-compete. So those are right now the only 4 items of consideration that the state of Texas recognizes as legitimate for the support of a non-compete agreement. So let's say what is not legitimate consideration. Employment in and of itself is not legitimate consideration. Money, like a bonus, is not legitimate consideration. Salary is not legitimate consideration. A car, you name it. If it isn't in one of the 4 categories that I mentioned, it isn't considered legitimate consideration, although it might be something that is given along with one of those other 4 items that I mentioned. And those are equity, confidential information, goodwill, specialized training. Okay. So in a physician non-compete agreement, Texas has some other very specific laws that are required, and a physician non-compete agreement is only enforceable in the state of Texas if the following criteria are established. 1, the non-compete must provide the physician with access to medical records for a patient that he or she has treated in the year prior to separating from the practice. Okay, that's 1. Number 2, the agreement must allow for the patient lists and records to be accessible to the physician in the format in which they are kept in the ordinary course of business of the medical practice for those patients that have been treated for the year prior to separating from practice. Number 3, the agreement must permit the physician to continue treating patients with acute illnesses even after his or her contract or employment has terminated. And then number 4, it must contain a provision allowing the physician to buy out of the agreement. And we'll talk about what that means, but it has to give you a right to pay some type of money in order to get out of the agreement. And that is a unique provision for physician non-competes. So let's talk about each of these areas. We talked about consideration, and that consideration is what makes a non-compete supportive of a legitimate business interest to make the restraint of trade, which is inherent in a non-compete or a restrictive covenant, legal or enforceable. So goodwill and the things that I mentioned earlier are things that make the Texas Supreme Court has made their decision that those things are a reasonable business interest to support keeping you from going to work for a competitor for a period of time after you leave your employment. I talked about a few things that have to be reasonable. 1 is scope of activity. What does that mean exactly? That means it has to be limited to what you do or what you have done within a specific period of time before you leave your job. Many times what you will see is anything, it'll be a provision that will say any work that a physician has done in an office for the employer over the past 2 years. Or it may say any work in a certain area of practice. So for example, if it is a limb lengthening practice or an ENT practice, where it specifically says what practice you're limited from doing for a particular period of time. It has to be very narrow. Second is the geographic area. Now that can change from place to place. So in Dallas, Texas, for example, where I am, a geographic restriction of 25 miles may be considered legitimate because the patients may decide that 25 miles is not an unreasonable distance to travel to see a physician. In other areas, maybe in rural areas, that type of restriction may be considered too limited, and that might not fly in a smaller community. Duration and time limits. What's reasonable for a duration and time limit? I mentioned earlier that you will commonly see time limits from about 6 months to 3 years. Years ago, it was a check the box. If it was somewhere within that range, courts and judges really didn't scrutinize it too much. But over the last 5 to 10 years, courts have become much less likely to blindly accept a 6 month to 3 year period, and have instead asked employers to justify the time period that they are requiring someone to sit out from a practice and not compete or not to solicit patients, etc. Some of the things that they look at is, what is a patient turnover rate? Or what is the length of a contract? Or how long does it take for a patient to move through the system in whatever health practice that you're in? So for example, if a patient might be for a surgery, might have the initial appointment, there might be a surgery and then some follow-up care. Is that a 6 month period, a 1 year period? What is reasonable to keep someone from competing where they're not taking money out of the former employer's pocket by using confidential information or the goodwill of the company, or specialized training that the company provided to it in a way that the state has deemed to be unfair competition? So if you have an agreement that has any of these types of restrictions, scope of activity, geographic area, and duration or time limits, it's good to get counsel, legal counsel, to look at that and talk with you about whether or not those restrictions are reasonable before you sign the agreement. You have a lot more leverage and ability to negotiate these provisions before you sign the agreement. Once you've signed it, it is almost impossible to affect change for that agreement, not just during that employment term, whatever that contract term might be, but for the life of your employment with that employer. It will be very difficult to pull back on those terms. So let's talk about trends and laws in other states. The trend right now is towards scrutiny of non-competes. In Texas, it used to be that you would hear people say that non-competes are just not enforceable in Texas. And maybe 25 years ago, when I first started practicing law, that was more of a true statement than it is today. As the years have passed and there has become more understanding about why non-compete agreements might be helpful to a healthcare practice, it has become easier to enforce a non-compete or a non-solicit of patients, etc. But on the flip side, the courts are scrutinizing them more to make sure that they are only enforceable to the degree that is reasonable for a limitation on the physician, and only to the degree that is reasonably necessary to protect the company. So those are good things for both the healthcare practices and physicians. So let's talk about some of the other states that you might end up practicing in or you may be interested in. In the state of Massachusetts, they have adopted a law that statutorily prohibits any physician restrictive covenants. Colorado and Delaware also similarly prohibit physician restrictive covenants, and Rhode Island just recently adopted a similar law. Now, there are some states that don't outright prohibit physician restrictive covenants, but they have stricter standards. And I would say Texas does have some strict standards, but if you're looking at Tennessee or New Mexico or Connecticut, there are some special laws in those states that make it difficult to enforce non-competes against physicians. The state of California and Oklahoma, both of those states are very anti-non-competes. And so those states are unique in that they have a ban on any non-compete agreements throughout the state for any type of employee or worker. Recently, a few years ago, just before COVID, the state of Florida passed a law that prohibits any physician non-competes between physicians and employers in rural areas who practice a specific specialty within the same county. So in other words, you can't, in a rural area in Florida, they don't want to limit their physicians in these rural counties from being able to practice because they need the doctors doing what they're doing in the rural areas. And it's hard, as you probably already know, to attract physicians to the rural areas. So that law has passed, and the trend is going in that direction. In fact, there is a public policy that is relatively strong that affects physician non-compete agreements, not just in rural counties, but overall throughout the country. And the public policy argument essentially is, if this is a specialty area or a special region that doesn't have the luxury of losing a physician for a year or 2 years because it is just so needed. For example, I mentioned earlier limb lengthening physicians. There's not a lot. They're spread throughout the country. But if one were to go out on a non-compete and not be able to practice, that would have a significant impact on the state of our healthcare across the country. I want to talk a bit about buyout prices for a physician non-compete agreement that I mentioned earlier. In Texas, there is the unique requirement that physicians are allowed to buy out their non-compete agreement. You can't require them to buy out, but you must have a buyout provision in the agreement. And what does that mean? That means that by Texas law, a physician non-compete agreement must provide for a buyout of the non-compete covenant by the physician at a reasonable price or at the option of either party to be determined by an arbitrator. So in other words, if it's not a reasonable price and the physician says this is not a reasonable price, then the contract must allow the parties to go to an arbitrator and allow the arbitrator to determine whether or not that's reasonable and whether they can renegotiate the agreement for a reasonable price. And that buyout provision allows the departing physician to essentially buy out the restrictions and move on so that it does not restrict their career opportunities. And frankly, a lot of the new employers that are hiring physicians, some of those will take on that financial responsibility and buy out the physicians so that they can move them into their practice. That's not a universal promise, so to speak, but I have seen that many times. Unfortunately, though, often the buyout can be significant or exorbitant, and that's why Texas law requires the arbitration provision. Again, you can't be forced to buy it out, but if you don't buy it out and the non-compete restriction is reasonable, then the employer could theoretically go to the court and enforce by getting an injunction and keeping you from practicing. And then you would be in litigation, which is incredibly expensive and not where you want to be. The only person who wants to be in litigation is a lawyer. And for a lawyer like me, I love litigation, but I hate the fact that physicians and employees have to go through litigation in order to further their career. And that's why it's really, really important when you get an employment agreement to take it to a lawyer, even though it does cost money to get an employer, a lawyer to look at the employer's employment agreement. It's definitely worth it. And I can't emphasize that enough. A few $1,000s to have someone look at it, review it, and help you negotiate it if necessary is much better than the multiple thousands of dollars, sometimes in the six figures or more, to litigate it on the other end. So before I finish, I'd like to talk about what has been on everyone's mind recently, and that is the Federal Trade Commission, the FTC's new non-compete rule, and how that might apply to physicians. First of all, the FTC rule, if it goes into effect, would go into effect on September 4th, and it has an all-out ban on non-competes, period. It has three main components. One, that a non-compete is an unfair method of of competition to keep someone from entering or exiting the workforce. And it does require an employer to notify employees that it no longer will enforce the non-competes. And the most important part, at least from my perspective, is that it purports to preempt state law. Now, this FTC non-compete rule is a subject of litigation in at least two courts that I'm aware of in Texas. And so whether or not it goes into effect is a big question mark right now. But how does it affect you if you're a physician? First, not all, but many healthcare entities and employers will be subject to the FTC's non-compete rule. However, it will not apply to some nonprofit healthcare entities. There are ambiguities there. There are questions about nonprofits that functionally exist to profit their members. There's questions about nonprofit organizations that use for-profit medical groups or professional corporations. And even more complicated, there are questions about its applicability to university-based hospitals or faculty practices. So it isn't a clear answer, but there are some ambiguities there. What the FTC's non-compete rule doesn't do is it does not disturb non-compete agreements made before the rule's effective date, and that effective date again is September 4th, if the worker is defined as a senior executive. And many physicians have asked me, as a physician or as a leader of a practice, would I be considered to be a senior executive? The answer is probably not. Very, very few people will be considered to be a senior executive under the FTC's rule as it is currently written. It has two components to it to be determined a senior executive. One component is you have to earn at least $151,164 per year. That's the 2025 salary threshold for a senior executive, and it mirrors the highly compensated employee under the Fair Labor Standards Act provisions. The other and most important is that this employee must have policy-making authority in order to be defined as a senior executive. And policy-making authority means that you have to have authority over a significant aspect of a business. It can't be that you're the head of a division. It has to be something more significant than that. So most physicians will not qualify as senior executives because they're not typically in policy-making positions for their employer organizations. Case by case for other types of provisions. So you hear the term non-compete, and the FTC's non-compete rule does apply solely to a true non-compete, which means you can't go work for a competitor for a certain period of time doing a certain thing in a certain geographic area. Now, as to non-solicits of employees or non-solicits of patients, the FTC's rule takes a different stance, and that is probably going to be decided more on a case-by-case basis. The other thing that it does not apply to, and non-competes in rules in general do not apply to, are the sale of a business or the ownership of equity in a business. So in other words, if you have a medical practice that you sell to another entity and you get paid for selling your ownership interest and you take on a non-compete in that sale and purchase agreement, the non-compete laws of the state of Texas and the FTC ban are probably not going to touch that too much, because that's not really an employee non-compete. That is a different kind of an animal. That is, you're selling a business, you're selling an equity ownership, and you are accepting as part of that an agreement not to compete. Same thing if you have equity in a business. So if I own a part of a business, or if you own part of a business and you have that ownership interest, you owe some duties to other owners and to the business itself, where a non-compete is a fair restriction, because you can't, as an owner, go out and harm the interest of the business that you own. I appreciate your time today and your attention. I'm going to leave some more information in the description below. And again, I welcome any calls or emails if you have any questions about this complex area of the law. I'm Mary Nix with the law firm of Lynn, Pinker, Hurst, and Schwegmann, and I thank you for allowing me the opportunity to talk to you today about restrictive covenants.